Great. Welcome to this session, updating on CEDR's model documents for 2023. My name is Frederick Way, and I'm the head of the CEDR Foundation, and I'm really delighted today to be joined by two of my colleagues, Lauren McGull, who's the Director of Commercial Services for CEDR, and Andy Rogers, who is the Principal Mediator for Media, Standards and Membership. And also later on this call, we'll be joined by three CEDR mediators, Tony Allen, Neil Goodrum and Kelly Stricklin-Coutinho, who are all on the drafting committee to talk through some of the more nuances and the narrative of the changes that we've made. Just to sort of set out some housekeeping as we get going. Firstly, this call is being recorded so that you can sort of watch later, and people who can't obviously join us can also see what we're talking about. But also to say that the model documents will all be released on the CEDR website this afternoon, the updated 2023 versions. And we will also be sending to everyone on the call and who signed up to this a sort of links to that, as well as a sort of a brief note on what the changes are, so that you'll be able to do that. Also, what we will do is shortly my colleague Andy will talk us through some of the changes before we get into that discussion. But we are aware that you may have questions. We have muted everyone on this call, just sort of to try and keep the noise level calm, because we know that there's probably lots of questions. But what we do is to ask you to please put them into the chat, and that will go to the host. So that will go to me and my colleague to be able to read through. And then what we'll do is we'll be able to ask those questions at the end. So if you've got any questions, please put them in the meeting chat, and that will come to us as hosts. So I think that sort of covers everything that we're doing. So without sort of further ado then, I will ask my colleague Andy Rogers to now talk us through the changes, the key changes in the 2023 documents.
Thank you, Frederick. And thank you very much, everyone, for giving up what I would imagine is your lunch hour. So if we see you stuffing away a cheese sandwich, there'll be no hard feelings. So the model documents is very much a core part of CEDR as an alternative dispute resolution centre. It was one of the first things that we ever produced, and we used to work on a numbering system, and that changed a few years ago because different documents within the model documents had different levels of update. So we would simultaneously have a 13th edition and a 14th edition, and then confusingly, maybe we had a 15th edition come out in 2015. So actually we decided what was more straightforward was just to put a date every time that there was an update to the document. So all the documents would be updated with the new date at once, and everyone would have an understanding of what was happening. And just to stress the point, these are living documents, as in they respond to changes in the market, changes in court practice, changes in common law. And so we do update them, and Lauren was just reminding me of the major work that was done, obviously, when the pandemic hit, and a lot of the processes had to be amended quite quickly in order to be robust for operating online. So these are documents that are not set in stone. They are an expression of the moment. I'm going to briefly name check them. And then what I'm going to do is describe the overall themes of change, and then give some examples of what some of the changes have been. I should probably start by caveating to say the changes in themselves are not dramatic, and no mediator or litigator or dispute resolution practitioner on this call need to be fearful that they need to relearn a whole system of working. We feel that these are very straightforward changes that have taken place. So just to go through what is in the model document toolkit, we have a number of ADR contract clauses, and included in that is the international mediation clause, which is available, I think, in 26 languages. So that is very much available for people who are thinking about, interested in putting in clauses into their contract. And we do find that a number of our work comes through clauses being triggered and coming to CEDR. Alongside that, we have an independent ADR notice. So this is something that was created because it started being talked about in the civil procedure rules. So this is where one party wants to notify another party of the intention to mediate, and they're looking for a vehicle to do that outside of normal correspondence. So it's a form that can easily be filled in, and it comes in very handy if there is a contract clause being triggered, because you can just reference the contract clause. In terms of the other model documents, we have a model mediation procedure document, and which is the main document governing the way in which mediation works. And alongside that, the model mediation agreement, the agreement to mediate. We also have documents relating to the end of the procedure, as in a model settlement agreement, and alongside that, the model Tomlin order. Historically, the model Tomlin order always used to be the most downloaded part of the CEDR website, because I think what would tend to happen was the solicitors would turn up to mediation thinking, or maybe not expecting settlement, finding that settlement had happened, and then realizing that they wanted to have a way to inform the courts. So importantly, alongside that, we also have a code of conduct for mediators. We call it the code of conduct for third-party neutrals. It does very much apply to mediators, but other processes can come under that as well. We also have observer guidelines. So when mediators take observers with them, what is expected from the observer. And then we have advice on mediators working with technology. And most recently, we introduced as well just a note on the Singapore Convention on mediated settlements. So what has changed? Well, the three documents that have primarily been looked at, considered, and where changes have happened are the Model Mediation Agreement, the Model Mediation Procedure, and the Code of Conduct for Third-Party Neutrals. So I'm just going to talk through now very briefly the four kind of themes of the work of the drafting committee and what was done there. So two things that haven't happened, but it's important, I think, to say that they haven't happened. And two of the big things in terms of the zeitgeist of our times are the Ministry of Justice currently looking at what has been called mandatory mediation, but the Ministry of Justice are encouraging us to call it automatic referral to mediation. So the documents were reviewed with that in mind, and it was felt that actually, even if a party were directed, and obviously what the Ministry of Justice have been looking at is lower value cases, even if a party were mandated essentially to mediate prior to trial, that actually these documents still do what they need to do, and actually nothing necessarily needs to change. That doesn't mean that it won't change in the future. It just means that we couldn't actually perceive any need for doing anything. We feel that it does the task needed of it. And likewise, in relation to the Singapore Convention and the settlement arising from cross-border mediations, although the UK has not yet ratified the convention, it is conceivable that two parties that have ratified the convention would mediate in the UK, or that the UK might be dragged in, or the CEDR mediation might be dragged in, because there might be assets in a party that is in a country that is party to the convention. Again, we felt that actually what is currently in the convention, currently in the CEDR's model documents, does the job in terms of handling that. And the main issue there is that the need for proof that a mediation has arisen, a settlement agreement has arisen from a mediation. So those are just two areas where there is no change, but I wanted to explain why there was no change and the work that went into that. Three areas where there has been change, unsurprisingly, given the amount of and use of technology in mediations, certainly following the work done by CEDR in the pandemic, in terms of making online mediations safe and the process trustworthy, workable, etc. We have just had a look through those documents, and I'm going to nick a phrase that my colleague Richard Nunn used the other day. We've essentially made the documents agnostic as to whether the process happens in person or online. And there is enough wording now in both the Model Mediation Procedure and the Model Mediation Agreement that means that parties are free to opt for one, other, or a hybrid. And yeah, we feel that that is necessary and helpful, not least because a large number of cases are still obviously happening online, and historically CEDR's model documents were written for a process that happens in person. So that's one of the changes. Another area of change is encouraging the parties and particularly the signatories to the mediation agreement to take responsibility for different elements of the mediation. And I'll go through that in terms of the actual changes that we're seeing there. But in particular, I would reference it's things like making logistical arrangements, taking responsibility for explaining to that the signatory to the mediation agreement will explain to the rest of their party issues such as confidentiality, issues such as turning up to the mediation with authority to settle. So those are areas where there has been an improvement in terms of what we have been, what we now ask of the signatories. The other area to mention as well is, I mean, I've kind of blurred the two, but it is around the issue of authority. Let me go into the actual, and I'm not going to put the documents up on screen. I once went to a presentation on a change in arbitration rules by a very well-respected institution, where they went through the changes line by line, and I didn't personally find it very helpful to do that level of forensic inspection. So if someone does want to do that, you can feel free to contact me afterwards, and I'll give you the joy of doing that forensic inspection. But I'll just give you the highlights of what has changed in the documents. So in the model mediation, and forgive me, it's not all set in stone in my head, so I'll be turning to the side to look at my notes. So in the model mediation agreement, on the contract title page, the dating of the contract of the agreement can now be from the last electronic signature appended to the contract. That obviously allows for the fact that there might not be an in-person mediation, and parties are often encouraged to sign the mediation agreement prior to a mediation day in any case. Also, some work has been done to make it clear that the mediation relates to the named parties, the mediator and CEDR, on the day, on a scheduled date. Before, in terms of what the mediation wasn't quite as clear. On page 3, under the definition of the mediation, we now allow for communication over any mediator that will be compliant with the model mediation procedure. So this allows different technology platforms to be used. And again, we have an online and remote section on page 3, and this obviously introduces agreement between the parties and the mediator for mediating elements of the process or the entire process online as needed. The point on authority, I will, was what I was referring to before. This has improved the language, and therefore the party signing now it's very clear they bind the rest of the party and confirm that to the terms of the mediation, and confirm that the party will have authority to settle. So it's now very clear that the signatory, usually a solicitor, needs to check that these two elements are in place, so that they've done their due diligence, they've spoken to their parties to say, look, you have been bound by the confidentiality of this agreement, and in addition to this, that you someone within your group is coming. I have said someone within your group is coming with the authority to settle. Under confidentiality and without prejudice, there are also some changes. Again, the party signatory takes responsibility for informing the parties of the provisions of confidentiality here, and we've simplified the language in terms of what the mediator may communicate to CEDR. So before, there were instances where the elements of the mediation confidentiality could be waived if CEDR needed to be informed. That is now it's clear that the parties sign up. If a problem arises that it's not within the mediator's ability to solve there and then, that the parties agree that confidentially the mediator can talk about it to CEDR, and CEDR will keep that matter confidential. So those are the changes to the Model Mediation Agreement. The Model Mediation Procedure, we have made a change to the what is mediation section at the start, that appears on page 2 of the document. And that language just now makes it very clear that parties should be reading that document in conjunction with the Code of Conduct for third-party neutrals. I'll touch on that at the very end, but that essentially gives an additional level of confidence in terms of what the mediator understands of the mediation, and the parties, should they wish to read the Code of Conduct as well, will understand what the mediator can and can't do in terms of the code that they have signed up to. So that obviously covers instances such as withdrawing from the mediation should there be a rare ethical issue in the matter. The big change here in the Model Mediation Procedure is around preparation for the mediation. So it now clarifies what the mediator can and should do, what CEDR can and should do, and most importantly, what the parties can and should do in relation to setting up the mediation. This specifically includes agreeing the starting time for the mediation, so it shouldn't just be left to the mediator or CEDR to agree what time the mediation starts, or a venue, or the technology on which the mediation takes place. So those the parties have a responsibility to do that, to get involved. They can't just leave it up to CEDR as the mediation provider or the mediator. In addition to that, it also importantly takes some of the burden off the mediator and CEDR in terms of documentation exchange. So the Model Mediation Procedure has a section on documentation where it says what should be produced, and but the I think the default, particularly if one party is slightly more reluctant, is that actually they, or less well organized, is that actually documentation doesn't get produced. The parties are told you have a role in doing this. It can't just be up to the mediator or CEDR to chase for the production of those pre-mediation documentations and their exchange. On the point of documentation, there is a new addition. We reference the Green Mediator Pledge, which CEDR is a signatory to, and therefore we encourage that copies of documentation be digital rather than printed where possible. I think that's something we can all ascribe to, and it also means that as mediators, we don't kind of within 6 months of our mediation have to go down to the garden shed and have a big bonfire of all the papers we've acquired in the last few months. We can delete them off our email systems and be secure in the knowledge that they have been deleted, whilst also knowing that we've reduced our carbon footprints as well. The final point I wanted to mention was the Code of Conduct for Third-Party Neutrals. Again, this very much ties back to the Model Mediation Procedure, because there were things in both documents that it helped to be read in conjunction with, but it didn't make sense to combine the two because the two documents have different purposes. One does govern how the mediator will behave, particularly in relation to confidentiality and what to do in certain, as I said, ethical challenging situations. Whereas the Model Mediation Procedure covers the confidentiality of how the process will work and the anticipated behaviour of those involved in the mediation, whereas the Code of Conduct can be a bit more explicit on that. So I realise that's a lot of information, and it's information on documents that you haven't yet seen. So, but as I said initially, I don't think that there should be anything in there that you as users of mediation or as mediators will find in any way challenging or confusing. I think they all make sense and they're logical updates based on what is happening currently in mediation. And with that in mind, that's the end of my presentation. If you do have questions, happy to take them at the end if you want to put them in the chat. But I'm going to hand over to Lauren McGill.
Great, thank you, Andy, and thanks for the sort of trot through the changes in new documents. For those of you who I haven't met before, who are on the call, I'm Lauren McGill. I'm the Director of Commercial Disputes here at CEDR, and I'm joined by 3 of our CEDR panel mediators who also were on the drafting committee. So that's Tony Allen, Neil Goodrum, and Kelly Stricklin-Coutinho. You can, hopefully they've now all appeared on everyone's screen. And so the idea of really this section of the presentation is to have a discussion on some of the thoughts and the trends that are coming out of what we had to change the documents to address. So the first thing I think really is looking at online mediation. You know, it really it went from essentially being non-existent in the beginning of 2020 to being the main mode of mediating through 2020 and most of 2021. And now in sort of the last 15 months, 12 to 15 months, we've really seen a migration back to in-person mediations. Although at CEDR, about 60% of our mediations still take place either online or in a hybrid environment. And it's really that hybrid environment that we've really seen come to the fore. So starting off, Neil, have you seen, what trends are you kind of seeing in relation to online mediation or hybrid mediation?
Yeah, thanks, Lauren. It's interesting, isn't it? You know, they talk about a problem being an opportunity, and the great thing that we've learned over the last, 2 years, 3 years, is how to communicate like this. And it's now very common that we do communicate through Zoom, Teams, or other platforms, whereas before the prospect of doing so was something that I think we all found quite intimidating and challenging, and we didn't do it because we didn't need to do it. I think now one of the big changes, and I'm sure some of our colleagues will have experienced this as well, is the ability to have more extensive pre-mediation contact with the lawyers and with the parties. It's very easy to set up, isn't it, a conference where you can have both the client and the lawyer for one of the parties together on screen. You can start to establish that relationship that's so important when we get into the mediation, whereas of course previously we tended to have a telephone conversation with the lawyers and say something like, you know, well, what's your experience of mediation been? And then you take them through it from there, and what time are we going to start and who's coming, and that was pretty much it. Whereas now we're having a much more extensive involvement doing that, and that means that I've found that I'm having pre-mediation calls, Zoom calls or Teams calls, not only with the solicitor who's conducting the case, but with their client, and quite often with counsel as well, if counsel is going to be at the mediation. So that's starting what we used to do on the day so much earlier. And perhaps another development around that is that we're having more of these. So whereas before it would be one telephone call, see you on the morning, it's now, well, okay, maybe we talk about something and maybe we should set up a call with your client present, maybe we should set up a call with counsel, you've got something to sort out, well, let's have another call later. So there's a lot more going on beforehand, which what is the main benefit? I think the main benefit is it gives us a better prospect of reaching a resolution on the day, or certainly moving the dial forward so far as that's concerned. It's more inclusive. I've seen situations where people are able to get involved who wouldn't be previously there. So it may be an expert or even counsel who's not coming to the mediation, who's available at some point during the day, and they will join either a joint session or more commonly a private session where you are with the parties for part of the day. And I think part of our job as mediators has come to managing the process in order to fit that kind of thing in, which I think is also helpful. Some of the challenges, sometimes I've found lawyers and parties aren't quite as sophisticated with this, and as a result you get into difficulties. So for example, I've had a number where the lawyers have said, oh, well, our client's coming into the office and they will be in the room with us, and so you've got everybody on one screen and you can't see everybody. You can only see the person that the laptop is pointing at, and that makes it very much more difficult, I found, to communicate with people and to have that relationship. Because you want to speak to the client, but the lawyer's on the screen. You know, can you put your client on the screen? And then they're all looking over each other's shoulders, and it's just it gets a bit chaotic. And there is also a practical problem which I've tried to resolve in the pre-mediation contact, which is, what if you want to have a private conversation with the lawyer without their client present? And they're all in the same room. So you need to sort of plan that and see if you can find a way of doing that. Two things, and then I'll finish. One is personal preference for Zoom. There's a lot of, obviously a lot of law firms, they have Teams, it's all part of their Microsoft platform, and they think it's fantastic, and that's great. But I found Zoom, Teams, whilst it's better than it used to be, It's still clunky in terms of organising private meetings. And that's the main difficulty with it. I don't have a problem with it otherwise, but if you can't manage private meetings smoothly, then that has an impact. And I think there is a greater potential for parties to be more sophisticated in terms of being flexible throughout the day. You know, the insurer who gets the telephone call at 5 o'clock and says, well, we want to do this deal, and the insurer is still at 9 o'clock in the morning. The opportunity to bring people in more during the day, and also to possibly consult with people who aren't there. I mean, how many of us have mediated and they said, well, counsel who isn't at the mediation, counsel's opinion is, and they've never moved from counsel's opinion because they're too afraid to do so. Whereas if there's a potential for getting counsel on screen or the expert on screen. But overall, I think this is fantastic development. I think there's a long way to go in terms of being more sophisticated with it.
Tony or Kelly, do you have anything you want to chip in? That was really helpful, Neil. It's helpful to kind of understand how.
I don't know whether people are still experiencing actual technical difficulties and drop-offs and in the middle of mediations and so on. And just to say a small tip that Heather and I actually explored when we were getting a little bit fed up with this was getting wire to the house. I can't remember if it's called line to the house or wire to the house, but now we have an actual cable that I think BT installed, and we haven't had any problems with it at all since then. It's been really, really reliable, and we've had meetings in our separate studies going on, and the clever little wire seems to be able to manage us both.
No,
Tony, I think because I'm just about to purchase that arrangement, but I think it's fibre, isn't it? Fibre to
the house. Fibre to the house. That's right. Fibre to the house. Thank you so much. And it wasn't incredibly expensive. I mean, and it's of course tax deductible. So. The other thing I was going to say about the advantage of technology, and can I express delight about DocuSign and the fact that we can now, at a much earlier stage, feel that there is a binding mediation agreement which everyone has signed up to, subject, of course, to their new duties to be aware of what it actually means. And line up those that they're representing. But I've always felt slightly anxious about only doing it on the day, and to feel that it's in place from day 2, at least, of making contact with people is a great relief.
Yeah, and it removes what I used to find, and I'm sure you did, that we could sometimes have an argument for half the day about the mediation agreement, which was a complete distraction. So that's all gone now.
Yeah, and just so people are aware, CEDR's practice is once the mediation is confirmed, we send out that agreement right away. So whether it's 2 months ahead of time or 2 days ahead of time, the party should get it within about 24 to 48 working hours, tops 2 working days from when we received confirmation. Kelly, did you have anything that you wanted to add on the technology front?
Yeah, I mean, I would absolutely echo what Tony and Neil have said about the benefits of fibre. And I'm also, I'm afraid to say, in slight preference on Zoom rather than Teams. On Teams, I do find that actually different organisations have different types of access. So sometimes if a person doesn't have access to the app, actually how Teams appears for them can have a bit less functionality. And that's quite tricky, actually, to have parties with different types of functionality on the call. My own experience is that the ability for online mediation to allow for less travel, less expense, helping vulnerable people to attend in a way that they perhaps might feel a bit uncomfortable with in person, and might just make people feel a bit more comfortable, is a huge benefit. In practical terms, I've seen a couple of cases where if the party is in their office and they need to get a bit of information, actually it's really easy to do that. They can nip across the office and get what they need, and that I think has a real advantage of making sure that we don't have to try and play telephone ping pong with whoever it is we need elsewhere. So I think that's a really good positive. For me, I think the biggest downside is, as Neil says, really that idea that when you're on a call, I mean, sure, we can see the four of us here pretty easily, but sometimes I found that the call is effectively a beautiful view of somebody's conference room, teeny tiny faces, and actually it's quite hard as a mediator to get a sense of what's going on in that room and reading the people there, because you can see tiny blurry people around you, and I think that is something which can be slightly lost in this context. So for me, it's all about the setup. So if you can set things up properly so that you do have people in a way that you can see them, so that you can set up your rooms and meet people properly when you need to, that makes a really big difference.
Yeah, and we
definitely. Sorry, I'm just going to say one more thing about the eternal discussion between Zoom and Teams, is that an awful lot of lay people, lay parties, particularly in the kind of cases that Neil and I often do, are very used to it, are very used to Zoom in a way they're not used to Teams. And they've been doing family quizzes on it during the lockdown and all kinds of social events, and so they are actually quite relaxed about the use of Teams in a way that I think is really helpful, that it aids their participation.
Yeah, and I think that leads quite nicely onto the next topic, which is, so we're talking about, selection of the type of forum that we would use. Andy touched earlier on, changes to the model documents in terms of confidentiality and how it really places the onus on the signatory to ensure that those attending from their party are aware and have agreed to the confidentiality terms before they attend. And so I think, Tony, what I was going to ask you is what are you seeing in terms of the levels of party preparedness at mediation, and what can mediators do? Maybe there's a ton that mediators can do, but in conscious of time, maybe your top 3 tips that mediators can do in order to get parties in the best space to make the most out of the mediation.
Yeah, I mean, I think to get them to believe that the occasion is actually a safe environment in which they are free without adverse consequence to participate in proposals to each other which cannot be repeated. The more I think about it, the more I believe that what mediation really offers is this safe space, which on the whole the judges are very willing to preserve. It's only things go slightly, I think badly wrong, that there's ever any temptation for them to peek behind the veil. But this is all about the language you use in preparation. It's the language you use when you're actually doing your opening at the mediation. Just reminding people that they can't mess up their case, that they can't be criticized for failing to settle. I mean, some people may feel that's rather risky for us to say that, you don't have to settle. On the other hand, I think if you free them from the fear that if they don't settle, they could be placing themselves in difficulty, they will do a better job of exploring the possibilities of getting an agreed outcome. So I think these are all important things that one needs to do. And I think it's important, particularly in the language you use when we're speaking to individual parties, which is a feature far more frequently encountered than it ever was. I mean, when I first started mediating, there were well-known mediators who say, I don't want to have any pre-contact with the parties. The first time I want to meet them is when they're sitting around a table in a joint meeting at the beginning of a mediation. And that antediluvian approach, I think, is long since gone. We are now very much trusted to be able to have pre-contact on a private basis with parties in a way that the other party will not be suspicious about, particularly if we're careful to lay the ground, name the problem, perhaps in a pre-email. I always now send a pre-email to everyone saying, I'm going to speak to people individually. It'll only be about the mediation process. It won't be about the substance of the dispute. And people are getting used to that now. And as Neil has been saying, it really lays the ground very importantly and very comfortably for people when they actually get there.
No, which I think is really helpful, and it is that change in preparedness. And Neil, you obviously touched on this in your talk earlier about sort of, what are we looking at for online trends and how that has impact preparedness. Kelly, have you seen sort of a change or a shift or any observations in terms of developments in this area?
Well, I think the two things that sort of come to mind for me are, first, lawyers and settlement agreements. So we've already touched on that. But it does happen in practice that you get to the stage where substantively everyone's agreed and people are then looking quite closely at the settlement terms in terms of the writing. It's not about the parties, it's not about the principles anymore. By principles, I don't mean, the fundamental principles. I mean, the key people at the mediation. It's not about them anymore. It's about the details of the agreement. And sometimes that toing and froing can be about things which are capable of agreement in advance. So it might be things which are sort of the general terms and so on. So that is, I think, something that's interesting and worth teasing out with the parties beforehand. It certainly concentrates minds if the parties even start to think about how they would phrase their terms if the mediation settled on their terms. So that's one part. And then the other part that I've seen quite a lot recently is around the extent of authority. It comes up all the time, of course, but it's one of those things that the two parties might come to the mediation thinking that they have authority, and a person might have authority from their board to settle up to a certain amount, and that's great. Sometimes they surprise themselves with where they decide they want to go on the day of the mediation, of course. And so that tension between, does the mediation end there or pause there to come back in due course once they've got more authority is a tricky one. And it just strikes me that in some circumstances it's worth speaking to them in advance. They may not want to tell you what their number is, that there's sort of their red line. But speaking to them and helping them to understand that they might need a backup plan in terms of, perhaps they do need to speak to somebody else at the board on the day. What's the time difference? Is there going to be somebody available at the right time? What's the potential procedure if they do need to get further authority and so on, I think makes a difference.
No, we've seen that, time and time again. And it also can, if you can't get that authority, can frustrate the process to the point where a settlement is not reached, even if it was capable of being reached. Neil, do you have anything you'd like to add on this?
I suppose just very, very briefly, because we are now partly through the technology being involved to a greater extent in the pre-mediation work, I'm finding parties appreciate you coming and saying, well, have you thought about this particular step that you might need? Something probably quite technical. Taking on from Kelly's point there, talking about authority, but talking about who's coming. So in the pre-mediation work, who's coming to the mediation? Would it help if so-and-so came? How would it help if so-and-so came? That kind of thing. And also just picking up potential pitfalls. So, you haven't disclosed your expert's report to the other side. Is that going to be a difficulty and therefore a barrier to resolution? And even little things like, Tony will appreciate this one. The number of times I've said to parties in clinical negligence cases, have you got an in-date CRU certificate? And they haven't, and so they've been able to get one. And if we'd have come to the mediation without that, it would have been a real barrier to settlement. So helping the parties with those kinds of things, I think we are in a better position to do, and they're also more willing to accept that support, if you like.
Can I buttress one of the things that you said, Neil, as to what technology makes possible, and that is the attendance for part of the day by people who would have used the excuse that they couldn't travel or couldn't spare the time to come in any way. And I think we're going to get better than that in future years, but certainly, for instance, in clinical negligence claims, I'm frustrated by how rarely one actually gets clinicians there to talk to their patient. One might be surprised that they'd be reluctant to do that, but perhaps not if they've been criticised. But it seems to me that we have got ways, and mediators, as Neil has said, must be imaginative about and spark the imaginations of parties and those who represent them to doing a better job for creating the event in the most effective form as they can.
Yes, and I think moving to a slightly different topic, which is that mediation is likely to be now moving, it's always been a consensual process and something that we've looked at. But as Andy had touched upon earlier in this session, it is very clear that we are looking at potential automatic referral, particularly in relation to cases up to 10,000 and possibly up to cases where the value of the claim is up to 25,000, at least as the initial step. And so that can change the dynamic of how the mediation works, but also it sort of opens up mediation to a new set of potential clients and potential litigants. So Kelly, what are your thoughts on automatic referral?
So I should start by saying that I'm absolutely an enthusiast. So it's one of those things. It's particularly in the context of looking at small claims. I think it's fair to say that often in that particular jurisdiction, problems are shoehorned into a legal dispute. So the law is being used as a tool to sort out what is effectively a relationship problem or potentially a small commercial problem and that sort of thing. And so the dispute is not really always about the technicalities of the law. It's really about the relationships. And thinking about that a little bit more, what a court can do in that context is to say one person is right and one person is wrong. It's an outcome and it's a clear outcome, but it's not necessarily one which helps the relationships at stake there. So it strikes me that there are lots of benefits to automatic referral in that context. One, because looking at the potential outcomes, mediation has the potential in that circumstance to actually result in a solution to the problem, but also an improvement to the relationships. And in the context of the small claims court, I think that's quite important. Of course, it's not always the case in the small claims court, because some of the cases are they're relatively small amounts of money, but they're not necessarily just about the relationship. And I think in that context, in that context, again, you can see that actually it's important that there is a result, but that's not necessarily one that needs to take up court time. So I think in the context of courts, particularly at the moment, being under a great deal of pressure to get through cases, and in the context with the recent audit saying, of course, that there is so much capacity in the civil and commercial mediation market, there is a very natural pairing there, I think, for disputes to be resolved in a way which is effective for the parties and which helps to relieve the pressure on the courts considerably. So I think that results hopefully in shorter timeframes in dealing with people's disputes and holistic outcomes, if I can put it that way. So that's my sort of first point of general enthusiasm for claims in that particular context. I think it's important to recognise that one of the reasons people are a little resistant to the idea of an automatic referral is that there are some types of disputes that are perhaps not wholly going to be resolved in a mediation. So that might be something where, for example, you have a novel point of law where it really is important that actually a court decides what the law is on that point. Okay, so appreciate that those sorts of things don't happen very often in the small claims court, but I'm just thinking, looking ahead at where this might develop. There are also, of course, those sorts of cases where perhaps one of the parties is limited in their discretion. So you might have, for example, a government body which is only entitled to settle on a certain basis, or you might have a regulatory body which can only do a certain number of things in the context of mediation. So recognizing those two potential restrictions, obviously it doesn't happen in a small claims court. It might happen if to the extent that mediation is extended in due course. But I would say that even in those circumstances, it is still the case that you might be able to narrow the points which are in dispute between the parties. So, were this to be extended a little further, I could see it still has value in that context. And then the final point that I wanted to make is just that I think an automatic referral system offers the parties an opportunity to better understand what the other person is saying. So very often in the small claims context, pieces of paper are traded which say what the arguments are. But that doesn't necessarily show you what the real problems are at stake, if you see what I mean. And so understanding what the other side is actually saying is something which can take place much more freely in a mediation. I think, as Tony was indicating earlier, that sense of freedom to discuss and see what the actual issues are. And I think that's very important. It helps the parties to see how serious each other is on particular points, which points perhaps less weight might need to be placed, and it helps you to assess your own case. And I think that's all really important. particularly in the context of small claims, but I could see that were this to be extended a little further, or were the judiciary to be to take this as a step towards more enthusiasm for mediation, I think it would be a very positive thing.
No, that's really helpful. Tony and Neil, I'm conscious of time, but do you want to give us kind of your very brief views on automatic referral?
I've never been against it, put it like that. What I would say is, what is very telling is that it hasn't needed any amendment to the CEDR Mediation Agreement. And I've been saying since I'm blue in the face that so long as voluntary is about, the concept of voluntary is about whether you can leave the mediation without adverse consequence. And many judges have misunderstood this over the years in when they've been considering it. How people get there is a matter for social policy, but once they're there, it is a voluntary process and no one can be compelled to continue or settle in any way. And I think that this dichotomy is now clear.
No, and I know, Tony, if anyone has any interest in Tony's views, Tony has written several articles on this. So I think you'll be able to find them. They're on CEDR's website as well. But there's quite a lot in terms of the history of how we've gotten here. And Neil, did you just want to add anything?
Yeah, very quickly. I mean, first of all, CEDR did a masterclass on this, which was Frederick and Andy, which is excellent, and I'm sure it's available on the website. So if people haven't watched that, have a look at it. I think that this is going to be another big influence on how we mediate. Because from what I understand, okay, we're going to have people who don't want to be there. Well, we have that anyway, so we can cope with that. And the process is dynamic, and what happens by the end of the day is quite often hugely different from where you were at the beginning of the day. I think the challenge is going to be in the process that we're going to be undertaking. You know, there's talk of time limited, the talk of mediators doing 2 and 3 a day. And that's going to change a lot of our, because our culture as mediators it's a little bit more long-legged, if you like. You take your time, it goes through the day, it lasts however long it lasts in most cases, unless you've done the London County Court mediations, of course. Whereas this is going to change the way we practice, and some of the things that we do differently, the skills that we practice in that mandatory short time-limited mediation is going to move across into what we do in the standard commercial mediations, I think, and it will affect our approach as mediators and possibly mediator training as well.
No, and I think that's right. And anyone who's ever heard me talk about this, I always talk about sort of the litigation train, right? So you launch your claim and you get on the train, and your final destination is court. And there's a series of stops along the way: disclosure, witness statements, expert reports, PTRs, all of that good stuff. But there's never ever been a mediation stop. It's more like an emergency lever that has to be pulled. And sometimes that can be really daunting for parties. They don't know when to deploy that tool. They don't know how to deploy that tool. And one of the things that automatic referral does is it puts that as a stop on the train. It might be a floating stop. We're not quite entirely sure how it's going to work, but it is, and it may be a different stop depending upon what kind of claim you have. But it does put it as a stop, which means it helps parties to focus their mind. It helps them to prepare better. It helps them to get in that space. So we do see it as a really positive thing. And on that note, I know we've eaten into some of the Q&A time. I'm now going to hand back to Frederick and Andy to see if we have any questions that have come through. But thank you very much, Neil, Tony, and Kelly, for your input.
Great, and thank you, Lauren, also for leading that. So we have got a few questions. If you've got any further ones, please do put them to the host so that we can see them. But I'm just going to deal with a couple of questions, and I'm going to ask actually Lauren, maybe if you've got a comment on this, and then ask some more which are more general. So the first one was about just from a practicality point of view. As we said at the start, we are going to publish these online. We've been asked if a tracked changes version will be produced. The short answer is no, because these are downloaded by about 20,000 people a year. it needs to look clean. What we will produce is a note which tells you what the changes are. So you will be able to do those, but there will not be a track changes version. We have had a question, and I'm going to answer this to the best of my abilities, but Lauren, correct me if I'm wrong. How applicable is this to other jurisdictions? The short answer is that the model documents are designed and have been with the English and Welsh courts in mind, and that's sort of what we're thinking of. They can be used in other jurisdictions, but with guidance. So the idea is that you would please think it through and add in and sort of get even your own legal advice if you need to. So there are sometimes, but the general principles work and are consistent. Lauren, would that be an answer you would give on that?
Yeah, I think I would go slightly a step further. I think if you are deploying this in a foreign jurisdiction, you need to get a lawyer who's qualified in that jurisdiction to look it over in the same way that you would as good prudence any contract. So things like legal privilege are different jurisdiction by jurisdiction. You need to think about how that applies. So these are documents which are drafted with the UK in mind. That being said, the overall, what protections in an ideal world do you want? What things do you want the clients to have thought about and to agree? That is all in the documents. So I think if you are going to use them in a foreign jurisdiction, I think, the legal, and you're talking about legal effect, you need to get a lawyer who is qualified in that jurisdiction to have a look at them and make a comment. We can't comment on that. But they give you a great starting point so that you don't have to start from scratch on those type of documents.
Brilliant. I've got a couple more questions, which I think are just more generally for the panel. So the first was about with the sort of increase in litigants in person and with sort of unrepresented parties, about the panel's view on sort of on the model procedure about the parties now being asked to do more sort of facilitating of things in advance, but also in terms of the settlement agreement. What is the panel's view on how far the mediator should go in supporting and facilitating this and working and helping the parties with that if they're unrepresented? So maybe just sort of if anyone has any views on that topic.
I'll jump in very quickly to say I think we've got two different kind of things here. We've got the start of the mediation and the end of the mediation. So the start of the mediation, which would be when a litigant in person might look at the model mediation procedure and the mediation agreement. Yes, it's important that they understand actually what is involved there, and the mediator be talking to them about a settlement agreement and the potential need for legal advice and creating an opportunity for that to take place. The litigant in person shouldn't really, except in very kind of anodyne circumstances where the legal issues are very low, ever really be taking a role, and if they're not a lawyer, in drafting the settlement agreement.
Great, thank you, Andy. I'm aware of time, and I think we have to end this call at 2. So just going to sort of, we had a question about whether or not the mediator should be the host of the online platform or not. I think our view is 100%. The mediator should be doing it and ask the parties to do that. Do not let the parties sort of make you not the host or sort of put you in cat ears or anything like that. Let's keep in control. That does cover it. If people have got further questions, please do contact us. Please contact foundation@cedar.com. We will send this note and we will answer you and also do any follow-ups on LinkedIn and etc. about any other questions that come to mind. But I'm aware of time, so I want to say thank you to everyone who's attended, and particularly thank you to the speakers, so to Lauren McGurl, Tony Allen, Neil Goodrum, Kelly Stricklin-Coutinho, and Andy Rogers. We will be circulating this, and you'll be able to watch this again to your heart's delight. So thank you to everyone for that. Great.
Yes, and just to interrupt, and thank you, Frederick, Andy, and Frank, who are all on the call, for organizing this and putting the whole event together. We really appreciate it.